Hey, everybody. I don't think there's anyone in here yet, but today is the day that Donna is going to be sentenced. She's looking at life for the charges. Poor Dan. It's taken how many years since 2019 to get all of the people charged and sentenced for this awful crime that they did to this poor man, all because she wanted her grandchildren. I mean, come on, that was just petty. Like, those are his children. He has every right to want to be in the same town as them. But anyways, I hope everybody's having a wonderful Monday. I guess the Daisy Link, they're not doing the trial today. So I changed it for tomorrow, which is okay. Not a big deal. There is, I put a thing on my shorts. There is a missing baby out of Georgia. His name is, let me check the name real quick. A cute baby, 6 months old. 6 months old, and they took 2 cars. Maybe we can just turn it on the YouTube and then just come back to this. Oh, wait. Maybe not. Maybe they're going to be starting. I don't know why I can't get that to come on. But let's turn that up. I don't know if they're going to come back or if they're going to start. I think it starts at 3 Eastern Eastern and 2 my time, which is Central. So So yeah, there's missing. I thought they were going to start, but I guess maybe not. I bring up missing baby and it brings up Emmanuel. In Georgia, Clayton County, Georgia. So this is 1 hour ago. It says police in Georgia. Am I unmute? No. Police in Georgia have started a search for a missing 6-month-old baby. According to the Clayton County Police Department, officers went to an apartment complex in the area to respond to a missing person report. 6-month-old Nakai Pratt was taken from his home Sunday morning by unknown suspects in an unknown direction. Don't sound good. Police told local news they do not have a description of who took Pratt at this time. Pratt is described as 2 feet 1 inches tall, weighing 11 pounds, with black hair and brown eyes. Anyone with information on Pratt's whereabouts, contact the police department 770-477-3747 or call 911. Isn't that terrible? 2 months old. Oh my God. My daughter went missing one time. Well, she wasn't missing. She was with my nephew, but he took her to the mall. And I didn't know where they went. And I was terrified. I was so scared. Like, I didn't know if I was ever going to see her again. Like, everything that could possibly run through my mind at that moment was going through my mind. And the cop was telling me that I can't bang on people's doors. And I said, well, if I could get in, I wouldn't be banging. So terrifying, just terrifying. But thank you so much for being here. And please don't forget to like, share, and subscribe. It's free. You don't have to do anything. And if you can, watch my videos. Trying to do everything to get, and if you can, watch my videos. Trying to do everything to get, and if you can, watch my videos. Trying to do everything to get, and if you can, watch my videos. Trying to do everything to get, and okay, I just want to make sure that I had it on the right screen. So they still haven't started yet. There was a plane crash this morning. I do believe, and I can never say the word, so I'm just going to say mass. I do believe 2 people are deceased and 1 person was injured. I think it was a medical helicopter. Are you guys seeing that? No, I wonder why. Are you guys seeing that? No, I wonder why. Are you guys seeing that? Oh, if it can go wrong, trust me, it will. I wonder why. Are you guys seeing that? Oh, if it can go wrong, trust me, it will. I wonder why. I'm trying to get. Oh, if it can go wrong, trust me. I think I'm supposed to. I keep losing the mouse. It will. I'm trying to get. Oh, if it can go wrong, trust me. So I guess we're just waiting for them to get started. I don't know what's going on with my computers. But at least we got it. On the one, so we don't have to worry about it. She looks scared right now. Donna, I think you probably should have made better choices. Better choices for yourself, my friend. Or you wouldn't be sitting in that situation. So what do you guys think? Do you think Wendy is going to get any type of charges? Now, I was told because she wasn't there, she, I guess, didn't know that she's not going to be charged for anything. Or the husband. So I guess that's okay too, right? Oh, her husband looks like he's about to have a stroke.
All rise for session. Honorable Judge Stephen Avery presiding.
Good afternoon, everyone. You can see that. I believe the defense had a witness that was going to be giving a statement over Zoom this afternoon.
That's correct, Judge.
Is there anyone that is going to be attending on behalf of the state as well?
Yes, Your Honor. The Markel family will be appearing by Zoom, but they're relying on their statements previously made.
I wonder how he's been doing since she's been in jail and he has that giant condominium all to himself overlooking the ocean. Maybe he'll downsize. What do y'all think? leave a comment. If you're watching this on the replay, leave a comment. Do you think Wendy will have any charges brought up against her? Let me know.
I won't read the phone number out loud, but his iPhone, one of the witnesses is about it.
I believe the gentleman appearing as our witness, Judge, his case.
Boy, she's looking rough. Got those fancy facials and massages and her.
Judge, the 647
I mean, she
number
still looks
belongs to Ms.
good for her age.
You can tell her to rejoin.
Wilson.
Everyone on the Zoom can keep themselves on mute until it is time for you to speak, please. We're here this afternoon for final disposition and sentencing in case number 2023 CF 3226, State versus Donna Adelson. Parties can make their appearances.
Georgia Kappelman for the state.
Joshua's on for the defense.
Jackie Fulford on behalf of Mrs. Adelson.
Have the parties received their copies of the pre-sentence investigation report?
Yes, Your Honor.
Yes, Judge.
Are there any objections that either party wishes to make to the pre-sentence investigation report?
No, sir.
There are corrections that would need to be made, Judge.
What are the corrections?
Would you like me to stay in here as the link?
Stand there.
On page 1, they have the date of arrest as November 20th, 2023. And she was actually arrested on November the 13th of 2023.
I will notate the, Ms. Kappelman, is there
No,
any challenge to those?
No, sir.
I will notate the copy then that will be filed with the clerk as November 13th of 2023. Go ahead.
On page number 5, there are several. The first place, near the top, it says wage salary, and this was supposed to be her current employment that she had, and it said $1,000. She did not have employment where she made $1,000. She was not receiving any salaried income, so that should be 0.
Ms. Kappelman, do you wish to be heard concerning this?
No, Your Honor.
So again, I will notate the wage salary as $0.00.
Thank you, Judge. The next, underneath there, it says the number of jobs in the past 2 years, 1. She has had no jobs. She's been employed the majority of the 2 years.
Which part of page 5 are you referring to?
Well, that's on page 5, right underneath the wage.
So no jobs, no employment.
Correct, that should be 0.
Ms. Kappelman, do you wish to be heard?
No, sir.
Notate that there has not been any employment or 0. Go ahead.
Thank you, Judge. Directly under there, it says months unemployed in the past 2 years, 0, and she's been unemployed for 2 years.
No
So
objection.
you're asking for that to be 24 months.
Correct.
Go ahead.
There are 2 typographical errors in the remarks section. The second line from the top under remarks says history, comma, she, where that's supposed to say the defendant.
Give me one moment, I'm finding it. You said history is the first word leading into the correction.
History is right next to the word she. You see that's on the second line down. It says remarks, and then the word right under there on my copy says history, comma, she.
Yes,
It should be the.
it's Campbell.
No objection.
Go ahead.
And then in the same paragraph, 4 lines down to the far right, it said who had fallen in. That should be ill, I-L-L.
No objection, Judge.
Go ahead, Ms. Wolford.
Yes, sir. Going down under the financial status to where it says estimated total debts. In the second line, it says a second mortgage was taken out to pay for their home. That should say legal expenses, not home.
No objection.
Go ahead, Ms. Wolford.
Yes, sir. The same section where it states remarks, 3 lines down, it says husband's dental practice. That's incorrect. The dental practice was not providing income prior to her arrest. She was only receiving Social Security assistance.
You're just asking husband's dental practice to be scratched through.
That's correct. The only income was, they listed Social Security, but they listed both.
No objection.
Well, anything else?
On page 7, Your Honor, about halfway down the page, it has the remarks section. And if you go 1, 2, 3 lines from the bottom where it's listing grandchildren, on the right, it has a child's name, 14, and then it says a female, 7. That's actually a male.
No objection.
Right, any other objections?
Not from the defense.
The court has reviewed the PSI report. And at this time, I will direct the clerk to file it as a part of the record. Ms. Kappelman, do you have any other witnesses or evidence that you wish to present as a part of your presentation today?
I have some documentation regarding cost of prosecution, Judge. Would you like that at this time?
Yes.
The state has put together a summary page and a thumb drive. We are requesting $723,123.68 in restitution. Defense advised that they want supporting documentation regarding this request, which is contained on this thumb drive. They're just receiving it today. So have not had an opportunity to review it. I think at this time, the parties are in agreement to ask Your Honor to order cost of prosecution and reserve regarding the amount, and we'll see if we can reach an agreement regarding the amount.
Very well.
So that's one item that's in dispute for today. Another issue, Judge, is the score sheet. I've prepared 2 score sheets. May I approach again?
You may.
First includes death points, bringing the lowest permissible prison sentence in months to 172.5. The second does not include the death points, bringing the lowest permissible prison sentence in months to 82.5.
Not sure what the
documentation
looks are
from
for.
yesterday that the defense objects to
Why
the
Donna has to give her
inclusion of
copy,
the death points.
Donna, she didn't do this.
The limited research that I've had an opportunity to do suggests that they should be included if the death was a direct result of the crime. I believe it was. The defense wants to argue otherwise, so whichever score sheet your honor chooses to go with, they're provided there for you. The state is requesting, are you ready for me to argue what I want for sentence? Okay.
Go ahead.
Obviously life on count one, Judge, we would ask for 30 years consecutive to count one on count two, and 30 years concurrent to count two, but also consecutive to count one on count three. I do not have any additional testimony or other evidence to provide, Your Honor.
We've had this issue of the death points being attached to the non-homicide offenses come up in other cases. Certainly the death points would attach if there were an offense that were being scored, but the first degree murder is not being scored on the score sheet. What would be the basis, Ms. Kappelman?
That the death resulted from the conspiracy. It wasn't just a conspiracy without a death. It was a conspiracy that directly resulted in a death, hence the death points are appropriate.
What is the defense's argument concerning the score sheet?
I'm doing my best, Your Honor, to look at the weather for the last week or so. It's the same argument that was made on behalf of Dr. Adelson post-conviction. Your Honor granted the correction of the score sheet. Solicitation and conspiracy do not require an actual death. And I'll just rely on the same cases that were relied on by Dr. Adelson. State versus Johnson, 561 Southern 2nd, 1321. The crime, quote from that case,
I don't know why my other screen's not working. I play one and then the other one stops. I can't do anything. See, my thing is I want it to be louder for you guys.
the crime of solicitation.
I don't know what's going on.
The actor.
The one who's standing by on Zoom is Dr. Ben Graber, who would like to make a statement on behalf of Mrs. Adelson.
Dr. Graber, if you at this time can please turn on your microphone. Please raise your right hand, sir. Dr. Graber, if you can raise your right hand to be sworn. Do you swear or affirm the testimony you're going to provide today will be the truth? I believe you have a volume problem, Dr. Graber. I can see your lips moving, but I can't hear you.
What the heck? Okay. I'll have to figure it out later. I'll have to
Yes,
figure it
just
out
so I
later.
can test that we do have proper
I was just trying to
audio.
make it louder.
Dr. Graber, before you get started, Mr. Markel, if you can turn on your microphone and say 1, 2, 3 for me so I can test this audio.
So I'll just sit down.
All right, he's not coming through either.
I don't know. It's working fine.
If you can say 1, 2, 3 while I test this equipment. All right, I can hear you now, but we can't get him on the loudspeaker. At least someone must have switched the audio settings. My mic's fine. It's the witnesses need to be heard. All right, thank you, Mr. Markel. I'm going to place you back on mute at this point.
Maybe instead of sticking them right
Dr.
on.
Graber, try to talk for me one more time.
Probably
1,
should
2,
have checked
3.
all that out, like me.
1, 2, 3. 1, 2, 3.
Judge and a Radio Shack, man, all in one. All right.
Working?
It is. Let me swear you in again, sir. Please raise your right hand.
Oh,
Do you swear
Donna
or
is
affirm
not
the
my
testimony you
No,
will
you
give today will
my
be the truth?
judge.
I do.
You can lower your head. If you're examining the witness, or is he reading a statement?
He's going to present a statement, Judge.
Dr. Graber, you may proceed at this time.
Thank you, Your Honor. I appreciate the opportunity to come and speak on behalf of Donna Adelson. If I can, let me just brief description of who I am, my background. I've been a friend of the Adelson family since 1979. First 20 years I knew them, we were actively engaged in many activities. The last 20 years, I haven't seen them that much until this trial became apparent to me. And my background is I'm a medical doctor practicing obstetrics and gynecology, 45 years here in Florida. I was also a state legislature from 1988 to 96, representing Coral Springs and parts of Broward County. I was the county commissioner in Broward County and mayor of Broward County for 1 year in 2006. Also a professor at the University of Florida Medical School and the University of Miami Medical School in clinical OBGYN. And I'm here to speak today on behalf of Donna Adelson, the person I've known for a great deal of time. Hi Donna, just want to say hi. I'm sorry I can't be there to hug you. And I'm sorry we didn't get to have that dinner after your trial was over. But I'm here to, on your behalf, to let you know that you have friends, and I believe in you. Let me say that, Tom, I never thought we'd be here at this situation when I first met you. It was a total shock to me and to our families. And it's a tragedy for me to have to be here to talk about this. I feel very bad for your family, for the Markel family, for the tragedy everyone's experiencing. To me, I've been following this for 2 years. It appears to be a dissolution of two families. My background is similar in many ways to both families. Like Ruth Markel, I'm the son, of Holocaust survivors. I actually was born in Germany as a displaced persons camp, came to the United States at the age of 18 months. So like the boys, Lincoln and Benjamin, I don't have a lot of recollection from the first beginning of my time in the United States, but they don't have the recollection of their father, which is very sad to me. But they do have families, and I had family. And we have to learn a great deal from our tragedies how to come back into life. My distress is not just for Donna and the Adelsons, but for the Markels as well, and especially for 3 generations of each family, which I see in tragic downward swing. And yet, I did meet Lincoln and Benjamin at the bar mitzvah last year, and I got to meet those 2 boys, wonderful boys. Unfortunately, I never got to meet Dan Markel, but I have read many of his articles. Very impressive, very brilliant, very talented man who made some very good points about the law and about compassion in the law, which he felt could be improved. And I agree with that. So part of what I'd like to say today is basically that I do believe that Donna is a victim of natural circumstance, but has been actively exploited by parties involved in this case. I believe she was exploited by her son. Knowing Donna, who was the youngest child in her family, knowing her mother, and how close she was with her mother, and understanding their love and need for family, it makes no sense to me that she would pursue an activity that will destroy 2 families like it has. However, having known her son and some of his issues, I believe Donna, in her own naive way, trying to be a loving mother, subdued by guilt, by silence, by denial, and perhaps even active exploitation, and used for activities she had no part of. So I believe she's innocent on all 3 counts, even though she was found guilty on all 3 counts. Part of my understanding is also that the victims here are both families, and to watch the hate and distress and the vengeance I see, it's a terrible thing to look at. As Holocaust survivors, you think we would understand that better, how damaging it is to families. I would have to say, my background, I grew up in the Bronx, with the public school system. I actually was at Queens College when Donna was there, but they didn't know her. She graduated a year after I did. My wife Sandy graduated from Queens College as well. In Coral Springs, we met up after being there a while, new young families, professionals trying to build a life, having children, building a community, which we did. So to see this situation occur, to me, it was devastating in many aspects. As a legislator, I can tell you that we see things in law. Even though I'm a doctor and I was chairman of healthcare, I was a Democrat, majority leader, and I sat on the Judiciary Committee for 2 years, and understand the laws. Even wrote some of the sentencing guidelines and participated in passing them at that time. And what I learned over the years is that I had the privilege of passing many laws, because I was a leader and was able to work both sides. So many of my laws exist in the books. I get calls from judges periodically asking me about the intent of the law, and I wrote it because they have a case, and it's come down to what did you intend to happen from this law? And they would ask my opinion, and they would use that information. So I'd like to look a little bit about the intent of the judicial guidelines for sentencing. I think the life without parole is a very harsh sentence. And that was not the intent, was to punish domestic cases with that, but they hit drug dealers and organized crime and dangerous to the public. But I think it's been switched over to be used in conspiracy theories against the average citizen, which is not the intent of the law, in my opinion. Second of all, I think that it's unfortunate that this case has gone into so many new victims. And we've already, you have 4 victims who have been found guilty of murder. 2 have committed the murder, maybe 1. The others are conspiracy theories. And I would believe that I would suggest that needs to be reviewed by the legislature. That's my opinion. Now, in this case,
Dr. Graber, before you continue, is this being offered as character? Because he is not an expert on the law.
It's character, Judge.
Very well. You may continue, Doctor.
yes, that's my opinion from my background. It's not, I'm not giving a professional opinion. I'm giving my personal opinion from experience. What I'm asking the court today is, to me, the court, the judicial system, the power of the judicial system is in the judge. And it is the judge who is the presenter of a safety net for the public. To show some compassion when the cold written law, with every box checked off, shows no compassion, where does the compassion come from? It should come from the judge, it should come from the jury. And I think that maybe that's something we have to consider. So at this point, what I'm saying is that I believe Donna Adelson is a 5-star mother, did everything she could do for her kids, for her family, for her community. She has no bad intentions. She's not a leader, she's a baby in her family. She's always been a follower. Yes, she makes noise and she complains, but that's not her behavior. This is not her profile. So I understand that nothing can be changed, but I want to put on record that I believe she is innocent of these 3 counts, and we believe her. With that, I would have to say, sometimes bad things happen to good people, and I think this is one of those cases, and it's unfortunate. For the families, I would ask, beg them, think about the 2 boys. Dad is not here, but a piece of him is here, and those 2 boys. And their future, they're both teenagers now, their future depends a lot on what's going on here, and how they're going to be perceived in the future, and how they will interpret the future based on this. So I think it's time for some compassion, some understanding, some forgiving. Perhaps it's time to take a step back and let everyone heal from this process. With that, I say to you, Donna, Daniel and I love you, we support you and the family, and we hope you the best. God bless you. And Ron, thank you for letting me speak.
Let's have an examination for the witness.
No, Judge.
Does the state have an examination for the witness?
No, sir.
Dr. Graber, you can remain on the Zoom. I would just ask you to mute yourself at this point.
Thank you.
Does have any other witnesses to present or evidence?
Yes, Judge, we have Rick Chagrin, who's present, who would like to make a brief statement.
Please raise your right hand, sir. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You can lower your hand. You may direct the witness or you may give a statement.
You can state your full name, please.
My name is Richard Gordon Chagrin.
And have you prepared a statement here today?
Yes, I have.
Okay, you can give that to the court at this time.
This on behalf of myself and my wife, Susan Brotman, an attorney at law. We have known Donna Adelson for over 35 years. She's been a dear friend and travel companion, and we are still in shock of her current circumstances. We know her to be a loving parent, wife, and grandparent. We stand behind her claim of innocence. We feel the trial was held in a county where there's been a lot of bad and inaccurate negative publicity, therefore not allowing a fair trial. We contend if a change of venue was granted, she would have been found not guilty. We are hopeful she will be relocated to South Florida, where she can pursue all legal remedies available. Thank you very much for your consideration.
Thank you.
These are character statements or quibbling about the evidence and the rulings?
These
forward.
character, Judge, they're here to talk about their friendship and time. Thank you.
Any witness examination for Mr. Chagrin?
Scott.
No, Your Honor.
You may be seated. Any other witnesses?
We did provide to the court, if you received your copy, Judge, some very short letters that were written as character support on behalf of Mrs. Adelson, if I may go through those at this time.
Go ahead.
Thank you. The first letter that was submitted to the court was by Annie Cunningham and Ronald Gutterson, who testified at trial. They say, "We are writing this letter to restate our knowledge and feelings regarding Donna Adelson. We have known Donna since 2009 and consider her to be our dearest friend. Donna is a kind, caring, loving person. She was always concerned with the welfare of others. She is not the monster portrayed by the media. Donna is incapable of threatening or harming anyone. Donna is almost 76 years old and in frail health after almost 2 years of incarceration. We will always believe her to be innocent and ask the court to take these factors into consideration when deciding Donna's sentence." Next, we submitted to the court was one of her longtime friends, Ruth Rosenberg, who wrote, "I immigrated to the USA from Israel when I was 1 month shy of 12. I lived in Israel in a town of 5,000 inhabitants where my family knew almost everyone and came to New York City, Queens, with a population of close to 8 million residents. To say it was a culture shock is an understatement. I didn't speak any English and physically looked like an underdeveloped child in comparison to the American girls my age. I entered the 7th grade in September, not knowing any English, the quote stranger in school. For several months, I sat by myself at lunchtime in the cafeteria, staring at the next table, where Donna and a group of her friends were conversing, laughing, and having a nice time. One day, Donna walked over to my table and asked me if I would like to join them, and of course, I said yes, please. That kind gesture started a 62-plus year friendship. She invited me to her house to meet her family, and over time, we became like sisters. I can recall several instances where Donna helped me obtain a job so I can help my parents financially. She introduced me to a family in a bungalow colony in the Catskills who needed a mother's helper for their daughters in the summer of '66. The money I earned helped my parents pay for the closing costs on their house. The following summer, she got me a job as a counselor at Camp Allegra in the Berkshires. When I had to decide on a career path, I consulted with Harvey and Donna about applying to dental school as my college advisor had recommended. Later that year, I was chosen to be the maid of honor at their wedding. We remained close friends throughout the years, even though we lived more than 1,000 miles apart. Our families visited each other periodically, making sure that our children and grandchildren got to know each other. We attended life cycle events of our children, bat and bar mitzvahs, weddings, special birthdays, etc., and now our grandchildren's. Donna has always been a kind-hearted, generous, loving, and caring. She is one of my best friends, and I will forever remember and appreciate how she helped me with English while I helped her with math in Parsons Junior High School and remained loyal through these 62-plus years. The situation she is in today is unimaginable to me. That is not the person I know and love." We also submitted a letter from Ron Ellis to the court. "My name is Ron Ellis, and I have had the privilege of knowing Donna Adelson for more than 30 years. I am writing to you in hope of offering some perspective on the woman I have come to know so well over the course of our long friendship. Donna has been a steady and caring presence in my life. When my stepson passed away 11 years ago at the age of 34, Donna was there for me in ways I will never forget. She sat with me in my grief, listened when I needed to talk, and offered comfort when I felt overwhelmed. That kindness and empathy is the Donna I know. Someone who shows up for her friends and offers strength in their darkest moments. Over the years, I have seen Donna's compassion extend beyond just me. She has been a devoted mother, a loyal friend, and someone who consistently tried to bring warmth and generosity to those around her. I understand fully the gravity of the situation before the court, but I hope that when you consider Donna's sentence, you will also weigh the years of kindness, care, and humanity she has shown to others. I believe that Donna still has the ability to contribute positively, even under these circumstances, and that she is capable of reflection and growth. I respectfully ask that you take these qualities into account when you make your decision. Thank you for your time and consideration. Respectfully, Ron Ellis." And then a brief letter from Marion and Tim Schaffman. She writes, "We have known Donna for over 50 years, and although we live far apart and have seen her often over the years, we wanted to share with you our impressions of the lovely person we have known. Donna has always been a loving, kind mother and wife, and also an exemplary daughter to her parents, who often stayed with their family. We have never heard her utter a negative word about anyone, and had tremendous pride in every member of her family. She retained many friends from her childhood and developed long, satisfying friendships with the new people she met throughout each stage of her life. Donna was always intelligent, charismatic, and sensitive to everyone. She always listened to anyone's problems and offered a helping hand when she could. Most notably, her genuine concern over our and others' health issues was truly appreciated. As you can see, it is very difficult for us to view her as anybody other than the sweet, caring person we knew. Sincerely, Marianne and Ted Schaffman." Next is a letter from Jessica Ussery. "Dear Judge Everett, my name is Jessica Ussery, and I am writing this letter to express my personal experiences and knowledge of Donna Adelson's character. Donna and I share a beloved grandson, Roman Harvey Adelson, born in 2017. My first memory of Donna is a video made and shared on Mother's Day 2017. Charlie Adelson surprised his mom with the news that he and my daughter Brianna were expecting a baby. It warmed my heart to watch Donna's genuine excitement and happiness caught on video. Our families began spending time together as events and celebrations took place. I recall Donna being warm and welcoming. As I got to know her more, there was no doubt in my mind that she was a loving and devoted wife, mother, and grandmother. Roman's birth was a scheduled cesarean section on December the 5th. On that day, I was overcome with mixed emotions of excitement and fear. A family awaited Roman's birth at the hospital during unnerving procedure. Donna was affectionate and compassionate, as I was visibly anxious and emotional. I will always remember how she reassured and calmed me that day. We shared tears of joy and the hugs when a beautiful and healthy boy came into this world. Donna was caring and supportive of Bree as a new mom. I have many fond memories of time spent with the Adelsons. Although Charlie and Bree were no longer a couple beyond Roman's first year, we all remained close. Donna has been kind, thoughtful, loving, and generous. Thank you sincerely for taking the time to read the letter, Jessica Ussery." And then a short letter to whom it may concern. "I've worked at Adelson Institute for Aesthetic and Implant Dentistry from October 3rd, 2011 to September of 2022. During my time of working there, I had the opportunity to experience the beautiful person that Donna Adelson is. Through my time of working often side by side with her, I've witnessed her grace and ability to diffuse upset patients. She is incredible with having compassion for others and is truly one of the sweetest people I know. She's so supportive and understanding when it comes to her employees. When an elderly person comes in as a patient, she always made sure they had assistance, whether needing help filling out forms or even opening the reception door for them. She always jumped at the opportunity to be kind and helpful. I witnessed this and I know it was sincere. I still use what I've learned from her and apply it while I'm at work every day. I recognize the gravity of the situation and understand the seriousness of the legal process, but I respectfully ask that you consider the positive qualities that define her. Sincerely, Erica Johnson." And then the last letter that we submitted from was Attorney Gary Cohn. He said, my name is Gary Cohen. I've been a member in good standing at the Florida Bar since 1980. I have known Donna and Harvey Adelson as personal friends and personal counsel for almost 40 years. Harvey was also my dentist for most of those years. I have been in the Adelson house, and they have been in mine numerous times over the years since their children were little ones. My wife and I have socialized with Harvey and Donna at dinners, blessed events such as bar and bat mitzvahs, and weddings, birthdays, and many other occasions. I've also traveled with them, including a wonderful trip to Africa with two of my sons several years ago. I therefore have had a unique opportunity to observe Donna under many circumstances. In all the time I have known her, I have literally never heard Donna raise her voice, lose her temper, act inappropriately, or treat anyone with less than full respect, and almost always with a smile on her face. I have never heard a bad word said about Donna from any other friend or person in my presence. She has always been an amazing mother to her children, and she and Harvey have had the most loving marriage that can be imagined. While I cannot comment on any of the facts of this case or any of the alleged events, I can say that the Donna I know is the last person I would ever think of when it comes to what has been this utterly horrible crime, dealing with the death of Dan Markel. Being a trial lawyer for 45 years, I fully believe in the jury system and understand that a jury has spoken. However, the woman I've known so well for so long also needs to be understood as the wonderful wife, mother, grandmother, and friend that she has been known to me. I only hope that this information can be of use to the court when it comes to the sentencing of Donna Adelson, Gary Cohen. At this time, I believe that Mrs. Adelson's husband, Harvey Adelson, would like to address the court.
Very well. Do you wish to enter these letters into evidence?
Yes, Judge.
Does the state have any objection?
No, Your Honor.
They will be composite defense 1 for sentencing.
Thank you, Judge.
Dr. Adelson, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, I do.
You can lower your hand. You may speak.
Thank you, Judge, and respected officers of the court for allowing me to speak. I have been Donna Adelson's husband for over 50 years. My wife sacrificed everything so that she could pour her heart and soul into our children, our grandchildren, and our marriage. This summer was our 54th wedding anniversary, and I had to spend it without her, hand in mind. She has done nothing wrong, and yet is being punished for a crime that she did not commit. I thought we lived in a different kind of world, but I guess I was wrong. I have listened, watched, and sat in the courtroom for the entire trial, and I could not help but scream in my mind by the witnesses that were brought forward by the prosecution who told outright lies. I didn't know that you could lie in a courtroom, but apparently you can. Danny's parents contend that they have never seen their grandchild. But for years they say they've never seen her. But Wendy has shared with me pictures and videos and letters from their visits. They have suffered immensely at the loss of their son, but they also contend to tell lies to the court about our grandchildren. Donna has always been a loving and caring wife and is innocent of the charges. A biased judge and jury were influenced by years of one-sided news pieces and
Before you
social
continue,
media.
Doctor, Ms. Fulford, this has nothing to do with the character of the defendant or relates to sentencing.
May I just a moment, please?
Go ahead.
Oh,
Just 1 second, please. Just 1 second, please.
All right, thank you for letting me continue. Donna did not participate in the heinous acts that she was convicted of doing. You are sending an innocent woman to prison. You have taken my wife and you have taken my life as well. And for what? This is not justice. It is vengeance, and it is wrong.
Do you have an examination for Dr. Adelson?
No, Your Honor. No, Judge.
Any other witness statements that you wish to give?
I don't believe so, just one second. We don't have any further witnesses, Judge, but Mrs. Adelson has decided she would like to make an unsworn statement to the court.
Unsworn?
Yes, Judge.
All of the witnesses will be sworn this afternoon if she wishes to speak.
Judge, case law indicates, confirms that the defendant has the right to make an unsworn statement prior to sentencing. The court, Rule 3.720B states the court shall entertain submissions and evidence by the parties that are relevant to the sentence. A number of cases, Your Honor, that have interpreted this, especially in a capital case, as the defendant having a right to make an unsworn statement. This is a capital.
Please give the citations.
Yes, Your Honor. Excuse me. First is Smith versus State, 268 Southern 3rd, 831. It's from the first DCA in 2019. You want me to continue, Your Honor?
Give me one moment.
Yes, sir.
Bringing up my Westlaw. Give the citation again.
Sure. It's 268 Southern 3rd, 831.
Which pinpoint site are you referring to in the case?
It's not, let's see. So, Your Honor, I'm going to give you this one. So Hill versus State, 246 Southern 3rd, 392. It's from the 4th District Court of Appeal.
One moment.
Yes, sir.
246 Southern 3rd with the last part.
392.
Well, seeing In the case where it does state the defendant has a right to make an unsworn statement, we will proceed.
Thank you, Your Honor.
Would you like Mrs. Adelson at the lectern or up here?
She can remain at council table.
Thank you. I'm going to move the microphone. I need to speak loudly because this is not amplified.
Okay. Is this loud enough, Judge?
I can hear you.
Thank you for letting me speak. My son-in-law, Dan Markel, was a fine and decent man. He was well-educated and passionate about his career. He was a good son-in-law, but more importantly, he was a caring and loving father. On July 18th, 2014, his car was followed, leaving his home. It should have been just like any other day, an ordinary day in the life of Ben and Lincoln's father, but it wasn't. He didn't know when he left his boys off at daycare that would be the last time he would see them and the last time they would see him. He didn't know when he went to the gym afterwards that would be the last time he would exercise. And he didn't know when he drove home that his life would end within minutes. Danny wasn't just being followed, he was being hunted. He was brutally murdered in broad daylight, sitting in his car, in his garage, by vicious killers. I cannot imagine the terror he felt when he saw a gun pointed at him through the window of his car. I cannot conceive of his heroic efforts to stay alive during the hours after the attack. Danny died in the early morning hours of July 19th. His death is a loss to his children, his parents, his sister, all of us in his family, his friends, his colleagues in the legal community, and to his students at FSU Law School. Danny's boys each have a photo of themselves with their Abba, their dad, beside their beds. They grew up kissing the framed photo and saying, "Good night, Abba, I love you." The pictures and memories are all they have because cruel, cold-hearted people took him from all of us who loved him. My heart was broken when Danny died. My grandsons were going to grow up without the father who loved them. I wondered, how could we help these boys through this trauma? It was then that my husband and I knew that the best way to honor Danny's memory would be to share with these children an abundance of love, the love that Danny would have given them if he were alive. It is interesting how the state can't make up its mind about who is what they call the, quote, mastermind behind this murder. In both of Catherine Magbanaw's trials, the state claimed she was the mastermind behind Danny's murder. In my son Charlie Adelson's trial, they claimed he was the mastermind. And now in my trial, they claimed that I, this grandma, was the mastermind behind the murder. I had no idea that other people planned to cut Danny's life short. And the people who did this are exactly where they deserve to be. But I had no knowledge that this horrible, evil act was going to take place. If I had become aware of this plan before Danny was murdered, I would have stopped it. With not one iota of actual evidence, the state convinced a Tallahassee jury that I solicited and conspired with other people to have Danny killed. Where is the evidence prior to the murder? The evidence beyond a reasonable doubt that the state needed to prove their case. Where is the evidence before July 18th, 2014 at 10:50 in the morning.
Before you continue,
That we
Mrs.
feel-
Adelson, as it relates to this statement, is the defense trying to re-argue the trial?
No, Judge, just giving Adelson an opportunity to be heard.
Mrs. Adelson, you certainly can continue. However, the court can take into consideration the utter lack of remorse that you are displaying. Please proceed if you desire to do so.
Where is the evidence before July 18th, 2014 at 10:50 a.m. that revealed that I had any involvement in this vile and horrific act? Where is the solicitation and conspiracy evidence? The state needed to show that there was evidence before the murder to convict me. The state couldn't show that because there wasn't any evidence. They were trying an innocent person. It makes you wonder if the jurors were sleeping when the state had Sergeant Corbett on the stand for hours. Their own star witness testified that my phone was never, I repeat, never at my son's house on the night of the murder. The state's theory that my husband and I dropped off money to my son was blown out of the water by their own witness. And yet, the state continued to push that story, that lie of the so-called money drop to the jury through the remainder of the trial. And the jury bought into it, hook, line, and sinker. Reasonable doubt. Many months ago, my attorneys filed a motion for a change of venue. An expert witness testified that Tallahassee had been barraged with over 9 years of negative social media, printed news, television news, and podcast publicity about my family. He explained to the court, both with evidence and demonstratives, that for me to receive a fair trial, it needed to be held in any of the researched and designated areas in the state of Florida other than Tallahassee. All I wanted was a level playing field, but the court wanted the trial here in the hotbed of Tallahassee. I sat through 3 days of jury selection. 180 potential jurors were asked if they had developed an opinion in my case. Those that answered yes also added, I believe she is guilty. Not one person, not one, said, I think she may be innocent. That should have been a clue to the court to grant our motion for a change of venue, but the court denied the motion. One of my jurors admitted during jury selection that she had background information concerning what one of the state's witnesses would be testifying about. Why was she allowed to be on my jury?
What moment?
Another juror.
Mrs. Fulford,
Oh, I didn't hear you.
Mr. Zolman, again, this has nothing to do with elocution of any sort. This is a raising of grievances, which are properly given to the appellate court. What does any of this have to do with sentencing?
Grab just one moment, please.
Turn that phone off or step out. When the phone is off. Please.
What happened to Danny is unforgivable. But I am an innocent woman convicted of this terrible crime without evidence. Danny was a brilliant legal scholar. He would have been appalled at the total lack of justice that went on during my trial. He would have been embarrassed to have his name associated with any of it. There are two crimes here. The first was Danny being viciously murdered. The second one is taking my life, the life of an innocent woman. Convicting me should not be retribution for Danny's death. That is not justice for Dan. I've always respected the law. I've never gotten a parking ticket, but I'm going to prison for a murder I did not commit. I do intend to file an appeal so that hopefully I have the opportunity to be given a fair trial outside of Tallahassee. 11 years ago, Danny was murdered and taken from all of us who loved him. For the past 9.5 years, the state has broadcast to the world, including Danny's parents and sister, that I hired hitmen to kill him. Never in a million years would I have wanted Danny to be harmed or killed, nor could I ever do something that would leave these two small boys to grow up without him. I love these boys more than life itself. This is a lifetime of loss for these children. They didn't deserve this. His family didn't deserve this. Danny didn't deserve this. And so, as I appear before you today, Your Honor, I promise you with my whole heart, I swear to you on my life, I was not involved in any way with Danny's murder. I was not.
Defense have any further argument to make?
You know, it's just simple. This judge does not like her or her family. He wants nothing to do with them.
I want to address the comment that the court made a few moments ago concerning considering lack of remorse in fashioning a sentence. Shepherd v. State 227.
I don't understand how. I mean, I think
3rd,
you know what she did was wrong.
746, the First District Court of Appeal.
But I feel she has some
that lack of remorse
I mean,
cannot
it
be
wasn't she wouldn't be
considered in fashioning an appropriate sentence. If this were a situation where remorse and admission of guilt may be grounds for mitigation, the lack of these factors cannot be used to increase the defendant's sentence. Such reliance violates the defendant's due process rights. And they also rely on Ritter v. State 885, Southern 2nd, 413, also a first DCA case.
I believe the Supreme Court has ruled on this issue concerning remorse and lack of showing remorse as well. If you need me to find the citation for you, I will.
Yes, please.
We'll take a 10-minute break.
Oh, we're going to take a break. Oh, wonderful.
And an officer drew his weapon and notified.
We'll resume at 4:16.
Additional officers then made the scene. The woman walked inside her home, threw a glass candle at the officers, striking an officer in the arm, causing minor injuries. Officers communicated with the woman through the open window for over 30 minutes. As officers jumped over the railing to the patio of the residence.
So what do you guys think? Do you think she's remorseful?
This is a very triggering video, okay? I want that out there for anybody that's watching. I know TCN is here. You're listening to both.
Yo, I'm live here. They can hear you. So let's check on that little boy that's missing. Let's see if he's any news on him. Yeah, let's check on the little missing boy. I'm kind of curious. The missing boy out of Georgia. Okay. So, sorry everyone, my whole computer just froze up and shut down. I guess that's how we handle things. My TV just throws a tantrum and shuts down. So I don't know what's going on with my phone or with my computer, but there was nothing on that website that showed anything. So just that he was still missing, unfortunately. So we're just waiting for them to come back. They're taking a 10-minute break. So I wonder where everybody is today. So what do you guys think Donna will get? I mean, for the rest of her life, she doesn't have much life. I mean, how many more years does she have? So we're just waiting for the judge to come back. I guess I don't understand the whole break. I guess they needed a break. You guys want to see my new setup? Wait, let me finish my cigarette dough. So I brought everything out to the living room, and I just love it. My computer's not doing so good. I guess it won't turn on. So that's where we're at. Computer. It keeps freezing up. I'm not sure why. I haven't had anything put on my computer besides YouTube and StreamYard. I haven't put no TikTok, no Facebook, nothing. Anyways, how's that? You guys like it?
Davis.
Briefly, Your
She's
Honor,
back.
Davis was not a capital case. This is a capital case. Although the criminal punishment code would only apply to the non-capital cases, I would argue that Your Honor, that is distinguishable under those circumstances.
I'm going to read from Head Note 8 and 9. Nor was Davis forced to choose between allocution and maintenance of his innocence. He certainly could have allocated without voicing his disagreement with the verdict, blaming the driver, the police, his lawyer, the trial court for his conviction, and attempting to explain his personal interpretations of the law to the judge. He could have asked for leniency without admitting guilt. He could have provided the judge with reasons to impose a sentence less than the maximum besides his claimed innocence. But he instead chose to make a lengthy statement claiming innocence, denying responsibility, and placing blame for his conviction on the alleged misconduct of others. The trial court was under no obligation to ignore such statements and did not err in considering those statements and imposing the legal sentence here. Do you have anything that distinguishes Davis in any way?
As I said, Your Honor, Davis was not a capital case.
Very well. Any other argument or evidence the defense wishes to present?
Yes, Judge, thank you.
Please move forward.
Your Honor, we're aware that in count one, the court has no choice but to sentence Mrs. Adelson to life for the first-degree murder charge. We are going to request a downward departure as to counts 2 and counts 3, the solicitation and the conspiracy counts.
What are the grounds?
Pardon me?
What are the grounds?
Yes. The grounds are, one is non-statutory, and that's disparity in the treatment between codependents. And the second reason is statutory, and it is Florida Statute 921.00262B. The defendant was an accomplice to the offense and was a relatively minor participant in the criminal conduct.
The evidence in support of sub B would be the trial record, or do you have something more specific?
For 4B, we're going to rely on the trial record with respect to the conduct of Mrs. Adelson, and we would ask the court to take judicial notice. Your Honor did preside over Charlie Adelson's trial, and the evidence regarding the other co-defendants' activities or participation was also brought out in the testimony in the trial of Mrs. Adelson, so we'd rely on that record, Judge.
Ms. Kappelman, as to the argued grounds for statutory mitigation and also non-statutory mitigation, does the state have any argument to make?
No, Your Honor.
You may continue.
Thank you, Judge. I'll start with the disparity. Do you need case law citations for this, or you're aware of it, Judge? Okay. First case would be Sanders v. State, 510 Southern 2nd, 296. This is a Florida Supreme Court case from 1987.
One moment. 510 Southern 2nd. What was the other part of the citation?
I have copies, Your Honor.
296, and that's Florida Supreme Court in 1987.
Go ahead.
State versus Fernandez, 927 Southern 2nd, 939, which is a third DCA case from 2006.
May I approach, Your Honor?
You may.
And then the third case, Judge, is State, I can't pronounce it, but State versus Kunkelmoller, 333 Southern 3rd, 335. That's a first DCA case from 2022, but it is distinguishable because it does not address the issue of culpability as the first two cases do, but I wanted to bring that to your attention.
May I continue?
Thank you, Judge. I'll start with the disparity argument, if I may, Your Honor. In this case, there have been several co-defendants who have either been tried or entered pleas and received sentences. I want to, for this particular argument, relate exclusively to Luis Rivera. He testified in the trial, and through himself and other witnesses, Your Honor has heard what he did in this case. And what he did in this case compared to what the state has alleged and the jury found that Mrs. Adelson did, the culpability levels are very different. Mr. Rivera was allowed to enter a plea to second-degree murder. And although, as the PSI indicates, he received a sentence of 19 years in the Department of Corrections, that was run concurrent with a sentence he was already serving in a completely unrelated matter in a federal case where he got a 12-year sentence. So the number of years that he will actually serve for his participation in the homicide of Dan Markel is 7 years in the state of Florida Department of Corrections. His conduct, as Your Honor can recall, is that he traveled to Tallahassee sometime in June and scoped out the home of Danny Markel, engaged in some drug activity with Sigfredo Garcia, and then returned to South Florida. A few weeks later, he returned to Tallahassee and again scoped out Danny Markel's house. But he didn't just do that. Prior to arriving in Tallahassee, with himself knowing that he and Sigfredo Garcia were going to kill Danny Markel, he purchased and provided the very firearm that was used to kill Danny. He came to Tallahassee and they sat in wait outside his home. They followed him with Mr. Rivera being the driver, followed him while he took his 2 little boys to daycare, and he sat and watched as Mr. Markel, hand in hand, took those children inside the daycare. He then followed Mr. Markel all the way to the gym, sitting in wait. What was he waiting for? He knew what he was waiting for. Mr. Markel did not. He had no clue these men were outside in a car just waiting for him to go to a place where they could shoot and kill him. And they waited until he exercised. They watched him get back into his vehicle, and then, like hunters, traveled and followed all of this time period straight to his home. And there was no hesitation. He knew exactly what they were going to do. Without any hesitation, they pulled right in behind Danny. Danny's car was still running, the garage door was up, and Sigfredo Garcia exits the car and shoots Danny Markel, having done nothing to these men, in the head twice. How Mr. Markel survived, I don't know. But then Luis Rivera is the getaway driver. They flee the scene, they flee Tallahassee, and then Mr. Rivera stops to allow Sigfredo Garcia to dispose of the murder weapon, which has never been found. And then he drives back to South Florida like nothing has happened, purchasing motorcycles and cars, but most importantly, getting paid for the work that he's just done. The payment came from Catherine Van, and I'll address her in the next segment. The point here is, Judge, that over time, reading different things, you've heard a lot of arguments about what Mrs. Adelson's participation allegedly was. But when it comes down to it, and I didn't mention, but Luis Rivera did have an extensive criminal history at the time that he committed this offense. What actually came out at trial with respect to Mrs. Adelson, and I'm saying this, understanding, as you've learned, that Mrs. Adelson still maintains that she is innocent of this conduct. But what the state was able to show through their testimony and evidence was that the role that she played, according to them in the prosecution, was very minimal. The evidence showed that she was very upset when relocation was denied in 2013, not knowing that her daughter had agreed to it, not knowing that until she sat here in trial hearing her daughter's testimony. She wrote some very ugly emails. She said some very ugly things.
But in not one of those emails did it ever say that she wished harm upon Danny Markel. And this was in 2013. The evidence was presented by the state that was over a year later that Danny was killed after relocation had been denied. Although they argued that there was continued hostility on the part of Mrs. Adelson regarding the issue of relocation, with the hundreds of thousands of emails they had, they didn't present evidence that this ongoing dispute was being brought up in any way between the parties. The relocation between them, that issue had stopped. The testimony that was elicited was that Charlie Adelson, the son of Mrs. Adelson, was the one who was close with Mrs. Adelson, and that when she had a problem, the argument from the state was, when she had a problem, Charlie was the problem solver. And the testimony at court that was presented by the state supported that theory, that Charlie was the problem solver. They further elicited evidence, testimony, that without any knowledge of what the phone calls were, Catherine Magdanowa testified that when she was with Charlie Adelson discussing scenarios, which she didn't describe what scenarios she was discussing, that on occasion there would be a phone call between Charlie and his mother. She didn't hear the mother speaking. In fact, he left the room when he talked to, allegedly, the mother, and he came back in. He never relayed to her any information about the phone call. But the state's theory and the evidence that they presented was because Donna Adelson had been so upset about the fact that relocation was denied, and she continued to be upset, according to the testimony, that Charlie Adelson took it upon himself to reach out to someone, which was his girlfriend, and have her get someone that she knew who could commit this murder, make contact with them. According to the testimony in the state, in this case, Charlie Adelson told Katie, Catherine Magdanowa, I'm not trying to be disrespectful, it's just as the names were reused, but Mrs. Magdanowa, that she wanted him killed and he would pay for that to happen. Her testimony was she had no idea what the payment was going to be, but she did in fact reach out to the father of her children, Sigfredo Garcia, and he agreed to commit the homicide. Mr. Garcia then elicited Luis Rivera to participate with him in the homicide, and I'm not going to go through all the evidence in the case. I want to focus on what Mrs. Adelson allegedly did. Up until the point of the homicide, the only evidence that was presented about Mrs. Adelson's participation were those ugly emails. And there's a distinction, as we discussed during the trial and sometimes even at sidebar, of the evidence being up to the moment that Mr. Markel was killed. Up to that time, the only evidence introduced by the state in this trial for that time period were those ugly emails.
I'm here, I just don't want to interrupt.
She called him very foul names. She said some ugly language. She clearly was not happy. And whatever conversations may have taken place while Catherine Magdanowa was inside Charlie Adelson's home and Charlie was outside talking to another person. Mrs. Adelson maintains her innocence, but
Oh, I accidentally bumped and this happened. Oh, this is not my day. I accidentally bumped and this happened. This is not my day. And then my computer is running
On the
really
statutory
slow.
basis, that the defendant was an accomplice to the offense and a relatively minor participant in the criminal conduct, some of what I've just argued applies to this one as well, Your Honor. But what I wanted to point out here were the ones that we didn't discuss. So Sigfredo Garcia was found guilty at trial, first-degree murder and conspiracy. His sentence was life on the homicide and an additional 30 years consecutive for the conspiracy count. He is the one who rode in the car. He is the one who obtained Luis Garcia to go with him. He is the one who sat in the seat knowing he was going to exit the car while they hunted down Danny Markel. And he's the one who got out and shot Danny Markel in cold blood. Left like nothing had ever happened. Along the way, made many stops, including getting out to hide the murder weapon, and then went on with his life. The killer is getting the same sentence that the lesser participant, the state is suggesting, get as well. Life in prison on count one, followed by 30 years for the conspiracy and solicitation. Luis Rivera, I've already told you what his role was. Catherine Magbanawah got the information from Charlie Adelson according to the evidence, and at his request, obtained someone, Sigfredo Garcia, to do the killing. She is the one who coordinated between Charlie Adelson and Sigfredo Garcia and Luis Rivera. Although she testified that she didn't know Luis Rivera was involved until after it was over, the evidence that the state submitted clearly contradicts that. She was communicating with Luis Rivera before, closely to the homicide, and then shortly thereafter. She's the one that spoke to him. She was sentenced on the first-degree murder to life in prison, and on the solicitation and conspiracy, she was sentenced to an additional 30 years. It was run consecutive. Again, the same sentence that they're asking for on Mrs. Adelson is the sentence that this woman who heard the request for a homicide, found the person to commit the homicide, stayed in communication with both of the individuals who are responsible for killing Danny Markel, followed up with them and provided payment to them, and then took payment back from them for her to keep for herself. She was also paid in this. She participated, knew it was happening. They had proof that she knew it was happening. That was submitted to the court. All of that evidence clearly distinguishable from the conduct that they presented in evidence about what Donna Adelson did. Charlie Adelson, according to the testimony in this trial and his own, Charlie Adelson wanted Danny Markel dead. So on his close or very first date with Catherine Magbanawah, he asks her out in public at Halloween, some Halloween function, hey, do you know anybody who could get somebody killed? According to her testimony, she followed through with that. With Charlie Adelson, never with Donna Adelson, never communicated with her in any way about this. She worked then, if that's what happened and that's what's been testified to, she worked with Charlie Adelson from October of 2013 until Danny Markel was brutally killed in July of 2014. That entire period, and there's evidence, she admitted to most of it, to her conduct, and there's evidence that was presented in this trial and Charlie's that that's what happened. They made this plan, and that his stapled money was used to pay the killers in this case some $130,000 in cash that was divided up amongst Sigfredo Garcia. Sorry, my mouth was getting dry. Excuse me.
Go ahead.
Thank you, Judge. It was divided up between Sigfredo Garcia, Catherine Magbanawah, and Luis Rivera. She then stayed in contact with Charlie Adelson. She convinced Charlie Adelson to get paychecks written to her, and she received those paychecks each time.
I'm sorry, I have to say this really quick, but why does she remind me of Tom Petty?
What Catherine Magbanawah did and what Charlie Adelson did, the evidence in this case, shows it went far beyond what the state's evidence showed that Donna did, up to and including the time that Danny was killed. So again, if you're going to rate the level of culpability in this case and consider Mrs. Adelson's conduct as compared to those, they're asking that she get the same sentence as both of the people who killed, well, one person that did the killing, Sigfredo, a far more extensive sentence than Luis Rivera, who participated in the killing himself and only got 7 years. The same as Catherine Magbanawa, that apparently worked on this according to the evidence for many, many months and stayed involved even after that. Charlie Adelson is the only one who got a higher sentence. His sentence was life on count 1, the homicide, followed by 30 years on count 2 and another 30 years on count 3, so everything being run consecutively. The evidence that the state has presented is that Charlie Adelson is the one who masterminded this. That's what they've shown. Even though they said Catherine Magbanawa wasn't her trial, if there's somebody who started this, according to the evidence, it's Charlie Adelson, not Donna Adelson. All the work being done was Charlie Adelson. All the money that was paid was Charlie Adelson's money. Mrs. Adelson, according to the state's evidence, did not do any of that. Again, they had hundreds of thousands of dollars or hundreds of thousands of emails. Never one in all of those emails that we all had to go through did Mrs. Adelson ever suggest any harm to Danny Markel in any way. I understand the verdict, and she has a right to take an appeal, and that's what she'll do. But the evidence in what was argued is very far different in theory than what was actually presented to this jury. And I'm requesting that Your Honor, in determining a sentence on counts 2 and 3, take into consideration that the amount of activity that everyone engaged in this case was far, far beyond what was alleged against Mrs. Adelson. They just didn't come up with the proof for that. They did prove to a jury that she was involved, but that proof and the actual evidence was very limited to the conduct that they say that she engaged in that resulted in Mr. Markel's death. I do want to remark, if I may, just briefly on the issue of remorse. Mrs. Adelson maintains her innocence, and as she has a lawful right to do, will seek an appeal. She may not get another trial. There may or may not be parts of the finding of the jury that is reversed. May not. They can do that on, the appellate court can do that on 1, 2, or 3 counts. There are lots of options that the appellate court has. The reason I say that is this. Mrs. Adelson, maintaining her innocence, could not have shown more remorse for the killing of Danny Markel. And in her statement, although some of it I know was bothersome to the court, in her statement, I hope you heard.
I wouldn't say bothersome to the court.
Okay.
Please continue.
Okay. I misread then. I apologize based on your comments. One of the things she said in her statement, after most of her statement being about the horrible thing that happened to Danny Markel, was that the people who were responsible for it were in prison. That's a pretty big statement considering what the state believes Mrs. Adelson's position is with respect to the others who've been prosecuted, convicted, and are serving sentences in the Florida Department of Corrections. I also want to say this. The defense's position in this case from start to finish has always been, on behalf of Mrs. Adelson, beyond respectful to the victim in this case, Danny Markel. He should not be lost in this case, and I said that in my opening statement. We presented evidence about a wonderful man he was. He did not deserve for this to happen. The Markels gave their statements at the conclusion of the verdict that was issued by the jury. And I listened to every single word. And every single word that they said came out of the terrible grief from the loss of their son and the feelings that they have developed over the course of this 11 years in prosecuting these various people and additional information that has been given to them. every word they had every right to say. The feelings that they had are exactly what they should have. What happened to Danny Markel, as Donna Adelson has said in her statement, could not have been more horrific. He was treated like an animal, completely unaware that there was any kind of problem, that he would have any kind of physical altercation with anybody. I'm positive the furthest thing from his mind that day was that someone was going to kill him in his garage at his home. He did not deserve what he got. It's been very clear in the prior prosecutions and what was presented in Mrs. Adelson's trial about the conduct of these other individuals. They do deserve to be where they are. They do. Their conduct is unimaginable to me, that human beings would engage in that kind of conduct to bring a man, an innocent man, a well-respected man, an amazing father, to take him away from his mother, his father, his sister, most importantly, his children. That was horrific. I understand why those sentences were imposed. Not for Mr. Rivera, but for the ones that were tried and convicted. In this case, Judge, based on the evidence that was presented, the defense is going to ask on counts 2 and 3 that you sentence Mrs. Adelson to 3 years in the Florida Department of Corrections, counts 2 and 3 to run concurrently. My understanding, in the court, the clerk can tell me if I'm wrong, but my understanding is Mrs. Adelson has 701 days credit time served. That's what we calculated.
I'll stipulate to 701, Your Honor.
Very well.
Anything more on counts 2 and 3, Judge? First of all, in order for it to assist Mrs. Adelson, she's going to have to be successful on count 1 on appeal. If she is, anything more than that period of time is going to basically be a death sentence for Mrs. Adelson. She is soon to be 76 years old. Her health has gotten worse while incarcerated, as anyone would probably expect. Her husband is 81 years old. Compared 3 years compared to the man who participated in the killing getting 7 years, I believe is a just and reasonable sentence for Mrs. Adelson. We are also going to ask, Your Honor, after imposing sentence, I know it's nothing but a recommendation, but we would ask if you make a recommendation to the Florida Department of Corrections that Mrs. Adelson be placed as close to Miami as possible, where her husband resides, so that she can have visitation. I understand we don't have any control over Department of Corrections, but we would appreciate that recommendation. And may I have just one moment, please?
Go ahead.
While she's doing that, Judge, I would ask that Ms. Adelson not be housed with Ms. McBannel, or at least have a separation, if you could recommend that. I know Ms. McBannel is currently at Lowell CI.
Yes, Judge, I thank you for that, Ms. Kappelman. I wanted to raise that issue because we did check into that. Judge, I contacted the Florida Department of Corrections. They did indicate that they would be able to keep them separate, but that doesn't necessarily mean that folks who are familiar with and friendly with Mrs. McBannel wouldn't be where Mrs. Adelson would be. So we are concerned about that, about her being placed at that facility. I didn't know it before, but the reception center for the women actually keep inmates there. So that, I know that's a possibility, but again, that's in Ocala, and we're respectfully requesting that she be placed closer to Miami. Thank you.
Going to review the last case the defense has presented for downward departure. Ms. Kappelman, you had something else?
No, Your Honor, I don't.
Review the cases for downward departure, or in support of downward departure, the defense has argued.
All right, y'all. Are you putting in the comments on what you think she's gonna get? I think he's gonna. Oh! Comments on what you think she's gonna get? Dang. I think he's gonna. Oh! I forgot I had that on. I think he's gonna sock it to her. What do you guys think? She's scared. You can look at her and tell she's scared. I'd be scared. She knows, man. That luxury lifestyle that she's lived her whole life is a thing in the past. So I'm sitting here on my computer and I'm frying chicken outside. I don't like the smell of fried chicken in the house. Well, that's the last time they'll see each other, but through glass walls. Isn't that sad? I think it's sad. I think it's really sad that he'll never see his wife. Well, I don't think they have conjugal visits, or are they even doing that stuff yet anymore? I don't know.
Having reviewed the cases presented by the defense concerning the downward departure, also as well the argument that has been presented, the court has reviewed its notes of the trial and will rule on the issue of downward departure at this point. Florida Supreme Court has a two-part test concerning whether a downward departure should be granted or could be granted by the trial court. The first is whether the trial court can impose a downward departure sentence based on a valid legal ground proven by a preponderance of the evidence. The second step is whether the trial court decides whether it should impose the downward departure based on the totality of the circumstances. As to both the non-statutory grounds that have been argued and the grounds contained within section 921.0026, subsection 2, subsection B, in reviewing the trial court's notes, what has been argued by both the defense and also as well the court's relying on the record itself, court will find that there is a ground for non-statutory downward departure, but it declines to exercise its discretion. As to the statutory ground, I will find that both the defendant was an accomplice to the offense and a relative minor participant in the criminal conduct. I will find that has not been proven, but in addition to, the court would still decline to exercise its discretion. As to the sentence in this matter, Ms. Adelson, please rise. Level of planning and coordination to bring the murder of Professor Markel to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub A Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
$2,100 as a fine pursuant to section 775.083, $105 as the 5% surcharge required by section 938.04, $20 as the court cost pursuant to section 938.06, crime stopper trust fund, $3 as a court cost pursuant to section 938.01, subsection 1, criminal justice trust fund, $50 pursuant to section 938.03, crimes compensation trust fund, $225 pursuant to section 938.05, local government criminal justice trust fund, $2 as a court cost pursuant to section 938.15, county criminal justice education, $50 as a court cost pursuant to section 775.083, subsection 2, county crime prevention, $65 as a court cost pursuant to section 939.185, county additional court costs, and $3 as a court cost pursuant to section 938.19, teen court assessment.
Is there any lawful objection by the defense to these assessments?
No, Your Honor.
They will be assessed at this time. The cost of prosecution, the court will reserve jurisdiction on to determine for 60 days. If a hearing needs to take place concerning this matter, that will take place at a future time. As the defense's request for the court to make a recommendation to the Department of Corrections to place Mrs. Adelson in a facility near Miami-Dade County, I have no problem making this recommendation. The Department of Corrections will have the final say because this is an administrative matter. I will also recommend to the department that Mrs. Adelson is not to be placed in any unit or facility that would also house Catherine McVanilaw. The court did previously award to the state, based on the September 17th, 2024 continuance of the trial, costs that were related to that. Ms. Kappelman, part of what you're seeking to pursue, is that included within that, or is that a separate number?
Are you speaking of the costs that were ordered in Charlie Adelson's trial?
No. The day Daniel Rashbaum withdrew from the case and the trial had to be continued.
Okay.
All costs related to moving witnesses and other matters.
Yes, sir. I don't know the answer to that, but I'll make sure that they're only in there once.
Very well. The defendant is to be fingerprinted, 30 days to appeal. Please file the appeal promptly.
May I approach the clerk? We have put I had written on the letters that I had, so we put a composite together and I've shown it to Mrs. Kappelman, who has no objection.
Please place the sticker on them so that way they can be admitted.
No objection.
We are in recess. Seven, 8, 2.
Well, everyone, I guess now she'll be going to her new home, prison, Florida. She will never see the ocean. Nothing like that ever again. I guess she should have thought about that. When we do dumb stuff, we get dumb prizes, and hers is prison. Was it really worth it? Well, I guess her daughter has the children now. That's what she fought for, right? Was for her daughter to have the children full time. That's terrible. That is just terrible. I feel bad. Rest in peace to Dan Markel. You finally got your justice, which is good. Justice is deserved. And I think that's it for today, guys. All right, don't forget to like, share, and subscribe. You all have a wonderful day, and I will see you tomorrow to resume the trial of Daisy Link. I thought they were going to do closing arguments on Friday, and I guess not. But anyways, you guys all have a wonderful evening, and stay safe out there, okay? All right, talk to you later. Bye-bye.